Okay, so next time we meet for this class is going to be on October 21st, because I guess next week it's not a, like CSI schedule, and maybe some time off, and some Wednesdays are not Wednesday schedule. So October 21st is the next day, and that's going to be a day of your exam. It's going to be the same thing as the first exam. It'll probably be less multiple choice questions. I have not created it yet. I'm waiting until we finish tonight's lecture, because tonight's material will also be included on the second exam, and I always take material that I test on from the lectures as opposed to just the textbook material. So it'll be, maybe I'm thinking it might be 25 multiple choice, 20 to 25 multiple choice, and it'll be more true and false. It'll be posted at 6:30. You'll have a requisite period of time to finish it, and that's pretty much it. Just so you know, historically speaking, the second exam seems to be the hardest one. Now, it may be because back in the day, pre-COVID, I used to have a lot more short answers that had to be completed. So it would really give me the opportunity to test how much you know. I'm not doing that, during COVID, when we're doing all this like online stuff. It's more of just the multiple choice and the true and false. It's open book, because again, I can't see what you're doing when you're at home. So I'm going to assume you are using your notes. So maybe you're going back to, lecture videos if you have the time, but you really need to understand the material. You need to understand the differences between certain concepts, the cases. There are not that many cases as opposed to the first third of the semester. So again, when I ask you about cases, it'll be just, what is the main concept? What is the main idea of this? And you kind of would just answer, and that was it. Always select the best possible answer. And as always, I'm going to post this recording onto YouTube, and then I'll send you a link for it. So if you have not been paying attention, maybe just watch the videos one more time and see the things that I hone in on, harp in on, tell you to write this down, and you should be just fine and dandy for your test. Again, today's October 7th. Please, 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 if you have not registered to vote, you must register to vote. The 9th, October 9th is the last day that you can do so if you are a resident of the state of New York. This is your civic duty. You see why I can't get a word in. This is your civic duty. You must do that. You must be involved. If you're interested in any candidate locally, whether it's city council, even though the race is not until I think June of next year, or if it's a congressional candidate, or if it's a a judicial candidate, if there's anybody that you're interested in that you may want to actually intern for, or work for, or campaign for, let me know, because if I have a connection with that person, you can get involved. And this is really just such an interesting year. Then you can really get involved and get into the thick of things. So I think it would be really great and wonderful if you do it. So yeah, with that said, I'm going to go ahead into our material for today. Today we're going to be covering chapters 15, 16, 17, and 18. And as you can see by the syllabus, chapter 16 is not that much. The material here is not much, because again, I break it down and kind of give it to you in its simplest possible form so you can kind of understand it. So as always, pay attention, try to engage. If you have any questions, just stop me. I just see a sea of names. Some of you have pictures, but they're like all still pictures. So it's as if I'm talking to myself. Just wonderful. Okay, so chapter 15 focuses on contracts that have to be in writing. If you recall, when we first started talking about contracts, I was telling you that I might have asked you, is an oral contract enforceable? And, the correct answer is sometimes, or maybe. It depends really on the facts and circumstances of the situation. Well, the law dictates that there are certain contracts that must be in writing in order for them to be valid. So oral contracts are fine and dandy, and they can be enforceable. However, there are some types of contracts that must be in writing in order for them to actually be enforceable. Even taking that stuff aside, I'm going to reiterate, why do I feel that contracts should always be in writing? simple things of like memory loss. If two people enter into a contract with one another and they don't write the things down, well, how do you know that they're going to remember? How do you know that they have the same understanding? How do you know that, 1 month down the line, or even like the next day or 2 days, they'll have the same recollection of exactly what happened and what they agreed to? The more information you put down in writing, the more details you can hash out, the better it is, because it's less likelihood that you will have a problem or a disagreement, right? There just could be simple, misunderstanding about things, but the more you flush it out, the more you talk about it and come up with possible scenarios, the better it is for you, because then at that point, you're just at least understanding where the other person is coming from. And so you're likely to have a long lasting relationship because you have realistic expectations of the other party. But with all that being said, there are some things that must be in writing to be enforceable. There's only a couple. The book, I believe, gives you 5. There are 3 that I really want you to know. I'm going to tell you all 5. I'll tell you all 5 just for fun. But there's going to be 3 that I really concentrate on. And the first one is, again, this is all in your textbook, chapter 15. But when somebody answers for the duty of another. So if you have entered into a contract, A and B relationship, and so let's say I owe Chase Bank a loan, and if the agreement was between me and Chase Bank. If I'm going to bring somebody else in to take over my loan to Chase Bank, that must be in writing. So when somebody else is coming in and taking over my loans or my relationship with a third party, that must be in writing in order for it to be effective. The second one is when you have an executor or administrator. So when somebody passes away and you're nominating an executor or an administrator to take over the estate, it cannot be verbal. You cannot say that I want this is the person I want to be in charge of my estate when I die. That must be in writing. It's clearly in writing when you have an executor because there's a will effectuated with it. You also have a law that spells out who the pecking order is, and then the court issues out the decision and or order that dictates who the person that's going to be in charge is. So that always has to be in writing. The next one is one I want you to know. It's actually, once I say it, you're gonna be like, oh, well, obviously. Contract of marriage. All right, contracts of marriage need to be in writing in order for them to be effective. Somebody tells you, okay, we're married, yay, wonderful. That's not good enough. You have to have a piece of paper that actually says that you are married in order for it to be an effective contractual relationship. That's number 3. Number 4, any agreement that has to do with the transfer of interest in land. Whenever we're transferring land, real property, that must be in writing. It doesn't matter how many handshakes you have. It doesn't matter, how many times you've dealt with that particular, agent or seller or developer. Any transfer of interest in land must be in writing in order for it to be effective. The last one, and this is something that's a little tricky, it's when agreements that are not going to be performed within 1 year. If they're going to take longer than 1 year to be performed, that also must be in writing. So this is a little tricky. But it's like if you enter into a business dealing with somebody and it's going to take you longer than 1 year, or you're entering into a contract for 2-year relationship, a business relationship, that must be in writing. If it's less than that, I'm hiring you temp, to be a secretary or a legal assistant, or to finish off the plumbing in my apartment, and I anticipate that that's going to be less than a year, then that does not have to be in writing. But again, why do you always want to put things in writing? It's because you have something to document. You have a piece, it's like a reference material that you can always go to. So marriage, things to be done in more than a year, and transfer of real property are the ones that I really want you to know. The other 2 are just kind of like, as an FYI. Different states could have other contractual obligations that they mandate that are also in writing. These are just the general ones that your textbook covers, and I think they also apply in the state of New York. So always just good to know. Let me just see here. Does anybody have any questions about this stuff before I move on to the next thing? Okay. Also, one of the other things, I mentioned this before, I see it in my notes, I'm going to mention it again. Any contract for something that's worth over $500, that also has to be in writing in order for it to be enforceable. I believe I mentioned that last time, but in case I didn't, I'm going to say it again. $500, that's a write it down moment. $500 or more, that also has to be in writing. Okay, if it's less than that, it does not need to be in writing in order for it to be enforceable. Okay, let me just make sure that this is on the syllabus before I ask you about this case. Okay, it is. Estate of Jackson versus Devons. Who wants to tell us about the estate of Jackson versus Devons?
I've read the case, though I don't know how much you understood because there are a lot of words that I don't understand. You know,
That's
I needed
okay.
help.
If you have a general idea, because as you can tell, like with the cases, I just want you to have like a general idea of what the principle is. So what is this case generally about?
It's generally about transferring a land from one person to another person. And after a couple of months, the person who transferred the land, he passed away. And so that's one thing I don't understand. Estates of that person, Jackson's, they require their land back, or I can't explain myself what exactly is estates of Jackson, what kind of institution.
Yeah,
Does
they
his
didn't.
family?
His estate, usually it's the family. So once somebody dies, and the estate is like the executor, the people that take over, or the person that takes over to manage, and they did not want to honor the agreement that he had entered into prior to his death.
Yeah, and they took it to court.
Yeah.
Basically, they draw. So he wanted to keep like a little part of the whole land that he transferred to his neighbors, but it wasn't described in the contract, that little part, which corner or middle of that estate, or that's how I understood it, I guess. So they didn't put any description of that piece of land that he wanted to keep, and they call witnesses, people who witnessed that agreement, contract, and based on that, they won the case. Basically, the family, right?
What? Well, not ultimately, but do you remember? I'm gonna just. There was actually somebody who had commented on this, and if you don't mind, Timmy, do you want to just say this out loud? What you wrote? Is that a no? Timothy. Okay. So this case is about, they had entered into an oral agreement, right, about where the land starts and where it ends, but because it wasn't in writing, the court did not enforce it because of the whole thing about whenever you're transferring a piece of real property, it must be written down exactly, like where it begins, where it ends. So if you tell somebody, you know, orally, hey, I'm going to sell you my house, and you have until all the way up to that fence, and you have until all the, you know, all the way up to that tree over there, and blah blah blah, but then it's not in writing, it's not enforceable. So you cannot use extrinsic evidence, outside evidence, testimony of other people to try to prove, well, that was my understanding, that's why I got into it in the first place. Whenever we deal with real property, land, houses, it has to be exact. If you've ever purchased a home, or if you've ever looked at a deed, you would see that it's actually very specific as to the points, like latitude and longitude of when it begins and when it ends. And so it's not, you know, sometimes when you get a piece of property, it's not a perfect square. You know, it has, you know, it starts from here, ends here, and then it's all over the place, but that's because it has to be that exact. Why are there disputes between neighbors? You know, sometimes when you purchase a piece of property, you technically own, you know, from A to, let's say Y. However, you know, your predecessor, the person that, you know, owned the house before you, they had a fence that was allowed the neighbor to have a few extra inches, but now you don't want to have the neighbor have a few extra inches. You want those few extra inches. And so neighbors will sometimes fight, and then you have to go and look at what each person actually owns, where it starts, where it ends. And then you can get into disputes as to whether or not, you know, you actually own it because you've, you know, owned it for this period of time and you had the expectation and blah, blah, blah. But again, it's so important whenever you're buying or selling land that your agreements are in writing. Otherwise, they can be invalidated. So good job, Martin and Tim. Okay. We talked about before, like the sale of goods. And whenever we talk about the sale of goods, Article 2 of the UCC applies. And the UCC says that the writing, you know, the document that people are entering into, it's sufficient, it's good enough, that shows that there's a contract between two sides. Now, there is, you know, the theory of promissory estoppel. We talked about this before, right? That promissory estoppel. What do you remember about the theory of promissory estoppel?
Essentially, somebody can be held to their verbal promises.
Yep. Yeah. An oral contract will be enforced if there is justifiable reliance because the court wants to avoid injustice. You know, an extra bonus points in your head. I don't have like stars or stickers to give out. Actually, I do have a sticker here that was on my little chair, but it's for my son. Do you remember the case associated with the theory of promissory estoppel? Am I asking for too much? This was last week. Skeba versus Cash. Skeba versus Cash. Know that case, guys, because I'm going to ask about this on the exam. So Skeba versus Cash is the case that talks about promissory estoppel. Now, there's another legal theory. Okay, now this one I have not actually discussed it before, but I'm going to discuss it now, and it is something that you need to know. The theory of it's called the parole evidence rule. And the parole evidence rule says, so whenever you're entering into a contract with somebody else, like a legitimate contract, there's negotiations that go back and forth, right? I want this part. I want, you know, let's say you're buying a house. Here's the standard contract. Somebody, you know, the purchaser is going to receive it. They're going to be like, no, I want you to add in that all fixtures are included. I want to make sure that I'm getting the nice chandelier, that I'm getting all the appliances, blah, blah, blah. And they go back and forth. The parole evidence rule says that whatever is in a contract in the four corners of the document is it. You can't say that I had a different understanding of this contract and that's why I signed it. You can't say that I had a conversation with, you know, the seller or the purchaser and he or she told me that I'm going to get X, Y, and Z. That stuff, the extraneous stuff, is not going to be counted when we're looking at a contract. When we look at a contract, according to the parole evidence rule, we look at the four corners of the document, and we don't look at any other extraneous or contemporaneous stuff, right? It doesn't add or change the contract. The contract is as it is, as it was written, okay? You need to know the parole evidence rule. Any questions on that? Okay, so that concludes everything I want you to know for chapter 15. Chapter 16. This chapter, again, it's a pretty short chapter. We might actually finish really early tonight. Chapter 16 focuses on third-party contracts. Now, what are third-party contracts? It's when you're involving, just what I'm saying, a third party to be part of your contract. And this is how you can actually do it. There's three ways that you can have a third-party contract. The first is either it's an assignment of rights. You've heard the word assignment before. When we talked about assigning a lease, right? That sounds familiar. You can also assign rights to a contract. what does assign mean when it comes to third-party contracts? You are assigning any and all rights that you had to somebody else. So you're no longer out, okay? You're no longer in it, I'm sorry. So that's what an assignment. Sometimes you can also bring a third party into the contract by a delegation of duties. I'm supposed to do X, Y, and Z. I'm going to assign those tasks to somebody else, thereby making them a part of the agreement, because now I'm relying on them to do X, Y, or Z. And the third way to assign a third party in a contract is to simply include it in the contract itself by saying, hey, we're going to allow a third party to do X, Y, and Z. So how do you do that? If I am if I'm entering into an agreement, I need a job printed, right? I need, so I go to somebody to design my stuff. Let's say I'm creating a postcard or a newsletter. I go to a company to design and print out my stuff. So they give me the design, I approve it, but they don't actually do the printing in their own shop. They farm that out to someone else. Well, that's a third party, right? That's a third party that's being brought into our contract. I could know it. That's fine. Or even if I don't know it, they could be assigning or delegating those duties to a third party. So if there's a problem with that print job, I can go after the person who I entered into a contract with, but I should also loop in that third party to make sure that I'm going after all the parties that I can actually like benefit from, like get money from. Okay, so that's that. Again, assignment, it's a voluntary transfer to a third party. You know, that's just, it's voluntary. It's an absolute thing. Write this down. This is a write it down moment. What is the requirement whenever we do an assignment? There's only one requirement to have an assignment. Only one requirement, and that's just intent. You don't need anything from them, right? If I have an intention to assign something to somebody else, that's all I need to fulfill the assignment, okay? So that's bringing in that third party. Intent is the only requirement for an assignment. Let me see here. Okay, there are some things you cannot assign. There are some duties you cannot assign. And generally speaking, they are things that are very highly personable, right? Very personal things. Things that could be perhaps expressly prohibited. The examples I like to give, right? 2 examples. First one is going to seem silly, but think about it in its simplest form. What is a marriage, right? A marriage is a contractual relationship between 2 people. If I decide to enter into a contract to marry you, you can no longer assign that contractual relationship with somebody else and then say, you know what, my intent was to assign you to somebody else, therefore you, meaning me, marry somebody else. Can't do that, right? Can't do that. So marriage is certainly something, as a contractual relationship, it's highly personal. You cannot assign that to other people. The other thing you cannot assign, and there are certain debates on there, are, I'll give you a couple more examples, not just one. If I wanted a family portrait done and I scour the internet and I find a particular artist that I want to use, and because I love his or her work and I think it's wonderful, blah, 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 I go to this person, I hire them to paint my family portrait. Can they then assign that duty to somebody else?
No.
No.
If it's in writing, then they can't assign it to somebody else.
Not even if it's in writing. That, even without it being in writing, should not be something that's assignable. Why? Because I'm hiring this particular talent. It's something particular to that person. Obviously, if it's in writing, goes without say. You don't have to, you know, they can't do it because it's, I want this particular artist. It's not like, now I'll give you a flip side. I hire a contractor to do my, you know, to put up the kitchen cabinets in my kitchen. I pay the general contractor. Whether he or she installs the cabinets himself or whether he hires his own people to do that, I don't care as long as my cabinets are put up. Now, let me give you this example. What if I want to hire, I have a lawsuit and I go to a law firm. I want Johnny Cochran on my case. But then when I go to court, he sends an associate. Can he assign that task?
Not really. You pay for him, so you want him there, right?
Okay. You say not really. Another person says no. Anybody else?
I don't know for certain, but I would assume lawyers have some ability to do that, as long as they're the one that has entered an appearance. I would think that they're able to send associates on a per diem basis, at least, to like cover them if they have something else going on.
Okay, that's good. It actually, I think somebody put it in the chat, it depends. It depends on whether or not this is a nothing hearing where we just, you know, the judge wants to make sure that all the papers are in order. Do I expect Johnny Cochran to write every single letter and email and do all the research? No. You know why? Because then if I'm hiring a Johnny Cochran type, right, I am paying $600 an hour for his services. Do I really need to pay $600 an hour to have him make copies of the papers that need to go to the opposition? No. There are some things he's going to assign to his associates, to his legal assistants, to his paralegal, and then I pay a lower rate for that. So if, however, this is the day of my trial, this is going to now go before the jury, do I expect Johnny Cochran to be there? Yes, I do, because I hired Johnny Cochran. Unless he is dying somewhere, I need him to be at my trial. Now, let me ask you this question. I need to have brain surgery. The frontal lobe of my brain, there was a tumor found, and I need to have surgery done. I scour the internet, and I find a doctor in California that is known to perform these types of surgeries. The day of surgery, I go in, they're about to put me under so they can operate, and I see a fourth-year resident. And she tells me she's about to do my surgery. Is that okay? Based on the fact pattern I gave you.
I don't think so. I know a case from New York City about a very famous doctor that he used to do this stuff, and I think they took his license.
Yeah.
I don't think that's allowed.
Yeah, that you can't. That's a clear no. Why? Because I did not find this person so they can have a resident practice on me, okay? And I have nothing against residents. Husband was a resident. Highly respect all, you know, physicians and all their education, blah, blah, blah. But when it's time to operate on my brain, I want this one particular person. Okay, so again, pay attention to the fact pattern I give you, and then you make your answer accordingly, whether or not that's something that can be assignable or not. Okay, any questions before I move on? Okay. Let me just see here. Chapter, what am I on? Chapter 15, chapter 16. Okay. Okay, the next case, I'm going to just talk about it very quickly, in re Magnus, and that's really about somebody that was, you know, a member of a prestigious golf club. And the issue here that you need to know is if you get, you know, if you're in one of those fancy clubs, you can't assign your membership to somebody else. Why? Because they are choosing you as the cream of the crop to be a member of this fancy club. So then you can't go ahead and say, oh no, I want my friend to go instead of me. It doesn't work like that. So, being a member of a fancy club is not something that you can assign. That must be pertaining to you only, because when you apply for these country clubs and these, organizations, you have to go through this whole process, pay a lot of money. So they want to make sure that they know who are their members. So bottom line is you cannot assign your membership to somebody else, okay? Let me see here. Of duties. Also, I think it goes without say, you cannot delegate illegal activity. Just in case you were wondering if you can, you can't, okay? So again, I'm hired to do kill somebody or rob a bank or whatever. I cannot assign that as a duty to somebody else and then think that if they don't do it that I have I have repercussions or I have a remedy against them. Do not assign anything illegal. Do not engage in anything illegal, okay? I think that's pretty much common sense, but I like to just put it in there just in case. So that actually takes care of chapter 16. I'm going to move right along to chapter 17. Hold on one second. Can you hear that sound in the background coming from me?
Yeah, we hear it, like birds chirping, something like that.
Something like that. All right, excuse me. Let me see if I can move my child away. I don't know if it's going to be there or not. It's not. Go over there. Go over there. Miserable. My life is miserable. Okay. All right. So we'll just try our best here. Okay, hold on. Okay, wonderful. So we're going to move on to chapter 17. So chapter 17 focuses on performance, breach, and discharge. And that's kind of like now what's happening once you've entered into a contract. So when we talk about, sometimes there's conditions that are put in a contract, right? So an express condition is a condition that must be met in order for the contract to actually go forward. So I am buying a car from you. I can put in there that I'm going to buy this car, but only subject to my mechanic inspecting it and telling me that there were in fact no accidents. So the express condition is I'm only going to buy it if my mechanic checks it out and says there's no accidents. If my mechanic checks it out and says there was in fact an accident, am I obligated to buy the car? I'm not. Why? Because I had that condition in there. If they look at the car and then there were no accidents, then I am obligated to continue and move through with the contract. So express conditions are conditions where the happening or the occurrence or non-occurrence of a particular event can dictate the outcome of the contract, whether or not things will go through or whether or not they will stop. This is a concept I always test on, okay? Satisfaction of a contracting party. Satisfaction of a contracting party is a very subjective satisfaction test, okay? If I'm hiring a painter or I'm hiring a somebody to do, mosaic tiling or somebody to write me a song, and I say, I put a clause in there, satisfaction of contracting party is a must, that means I'm only going to pay you if I'm satisfied with the product you give me. Website, you know, drafting or creation or whatever. If I have that clause in the contract between us, that means you give me a product, you draw that painting, you write that song, you create that website. If I'm not happy, I don't have to pay you. What's going to normally happen? I will tell you then, I don't like it. Change this, this, and that. You change it. You come back to me. I still don't like it. We can go 100 times, really. How long are you going to keep going? How long am I going to keep going? At some point, maybe I'll say, you know what, I don't want to work with you. And then I don't have to pay you. Why? Because I had that clause in there. You, on the other hand, will say, but I've already done, you know, 100 drafts for you. You got to pay me something. Well, was it reasonable, my demand? Maybe I wasn't reasonable, but because that clause was in there, satisfaction of a contracting party, that's totally subjective where, you know, it's completely up to me as to whether or not I'm satisfied. I really have the upper hand here. So those are not contracts or clauses you actually want to see if you're on the receiving end. Why? Because it's sometimes very, it's subjective. So you don't know, unless, you know, you might be dealing with somebody that's, you know, completely unreasonable. So you might want to make that customer happy, but how much effort, how much are you going to do in order to kind of get that? So that is satisfaction of a contracting party. Okay, the next legal concept is, I want you to know, is breach. What does breach mean? If you breach a contract, what does that mean? It means you're going to be liable. If you breach your end of a contract, yeah, that's right, break it. You're breaking that contract, you're going to be liable for whatever damages that, you know, can be attributed to you because you broke your contract, right? You breached it, you broke it, no good. Implied in fact conditions. Sometimes there are implied facts in the contractual obligation between two people. If I hire you to paint my house, what information do you need in order to carry out your job?
The colors you want to put on the walls?
Yeah, the colors I want, the type of paint, where am I doing the ceiling, am I not doing the ceiling? I have to give you specifics. So if I'm hiring you to paint, it's implied in that contractual relationship between the two of us that I'm going to give you some more guidance. Otherwise, you will not be able to fulfill your contractual obligations. There's no breach on your part if you haven't done it by a certain time, if I did not give you the information that you needed. Okay, so that's implied in fact conditions. Discharge by performance, it means it's actually a good thing. Discharge by performance is you performed what you needed to perform, you met your contractual obligation, therefore you are no longer obligated to do X, Y, and Z. The best example I can give you from that is when you buy a house, right? The agreement is not just between you as the purchaser, seller, as the homeowner. You also have that third party, right? The bank who's loaning you the money, loaning me the money so I can buy the house from you. I have to now pay that bank back. Once I'm completely finished with my mortgage, I get a discharge document that says I have performed my obligation. I have been discharged from the loan. I don't owe anything anymore. The agreement now, the contractual obligation between me and the bank has now concluded. So that is performance by discharge, discharge by performance. You can also have discharge by breach, which is now not a good thing because it means you broke your end of the contract somehow. And so now our agreement is we're no longer in a contractual obligation with one another. Why? Because you or me somehow breached it, broke the agreement, didn't do what we were supposed to do by the time we were supposed to do it. So it's effectively breached or discharged. Material breach. What is a material breach? I may ask you, for example, give me an example. Which one of these is an example of a material breach? What is a material breach? it's breaking of a contract, but it has to be something substantial. Okay, it's a material breach, a big thing that we had agreed on. Let's say we had a whole bunch of different things that we agreed on. Some things perhaps I could overlook, but I cannot overlook this. So if I hire you to build a home for me, 3-bedroom, 2-bath, a basement, and an attic, I want it all painted, off-white. You actually painted it all white instead of off-white. I have the basement. I have 1 bathroom and 1 bedroom. Do we have a material breach here? Yeah, you didn't build the essence of the house, the bedrooms that I wanted to do. So therefore, there's a material breach here. Yeah, you painted it. Great job. I don't care about the paint. I care about actually the number of rooms and bathrooms that were in the house. So material breach is it's a big deal. It's a big, an essence kind of thing. Sometimes there is something called, it's called discharge by agreement of the parties. Sometimes you have a contract between 2 entities, 2 parties, and for whatever reason, you guys are just not getting along, or this relationship is not what you thought it was going to be. It was not going to be as profitable. You're not happy with the work and you're not paying and you just want to kind of go your separate ways. So both sides can decide to just go their separate ways. So you don't want to actually continue working with this person. So that is a discharge by agreement of the parties. And the last thing is actually 2 other things for this chapter. Frustration of purpose. Sometimes you enter into agreement with somebody, but you somehow cannot get that done or you want to get out of the contract because the purpose of why you were entering into a contract in the first place is not happening. So for example, let's say I was to rent out a room on the route for the Macy's Day Parade, and I actually rented out this room or this apartment a year in advance. So November is next month, right? And I rented out this apartment so I can specifically watch the Macy's Day Parade. Now, COVID has happened and I'm not going to be able to watch the Macy's Day Parade. They're not going to put it on. They're not going to be doing the Macy's Day Parade. So can I get out of the contract? If I have the clause of frustration of purpose, I should be able to get out of that contract because my purpose is not being fulfilled. Even if it's not specifically written in there, I should be able to get out of that contract. Why? Because I only entered into a contract, this particular type of contract, for a specific purpose. And if that purpose is not going to be there, then I should be able to get out of that contract without having to pay any penalties. And it's not a breach. It's a frustration of purpose. Last for this chapter, I want you to know about bankruptcy. What is bankruptcy? You've heard the term before. Sometimes bankruptcy is something you declare when you cannot, pay your bills. You have a lot of creditors that you owe. And, bankruptcy sometimes is carried out by businesses. There's some different types of bankruptcy. Sometimes as a business, you can try to get rid of all your debt. Sometimes you can restructure. As a person, you can also, file for bankruptcy. I can't do this anymore, but what does it do to you? It ruins your credit. So you may have had a contractual obligation with all these people to pay them all this money, but it's like, I can't do it, guys. I have no money. I'm going to have to just file for bankruptcy. I cannot do it anymore. It just ruins your credit. So that is actually the last of chapter 17. I want to give you the secret message for tonight before I go on to chapter 18. So for tonight's, what's today? 10/7, 2020, Wednesday. Okay, the secret message is I like iced caramel lattes. I like iced caramel latte. Again, last time, the secret message for tonight's class, I like iced caramel lattes. Again, once you have 10 of these, feel free to email them to me all in one sheet, one email, and then I will input a grade of 100 for your attendance portion of the grade. So again, last time for this evening, I like iced caramel latte. can even read my own handwriting. Okay. The last chapter for the evening. Let's see here. Okay, it's remedies for breach. So we went through the whole process. We entered into a contract. We talked about performance of the contract. Now remedies. So what happens if there is in fact a breach of the contract? Well, the most common remedy for breach of contract is what? What do you think the most common remedy is?
Awarded damages?
Correct. Monetary damage. Yeah, monetary damages. So when you sue somebody for a breach of contract, chances are you want money. You want money because that's going to make you whole. That's going to make you happier. That's going to put you in the same position that you would have been had the contract actually been carried out. But there are, however, other types of damages that you can ask for, not monetary. Sometimes money is just not good enough. Sometimes you want specific performance. Specific performance is, I don't want your stinking money. I want you to do what you said you're going to do. And I'll give you an example of that. You enter, and this is actually kind of a true story. So back in, I don't know, many years ago, I wanted to buy a house. It was before I lived, where I'm at now. And my colleague at work was like, listen, down the block from us is this house. And I think it may be going through like some kind of estate problems. It was, owned by an elderly couple. They passed away and now the house is for sale. So it has an elevator in it. It had a pool. It was a huge yard. So I was like, okay, maybe if it's going for foreclosure, like I can get it for half price. Like maybe they're asking for $800,000. I could, offer $400,000, right? So I started doing some research, digging around, and I found that the case, it wasn't actually in foreclosure court, but it was tied to litigation. So what happened was the owners of the homes, when they purchased that house, they like gutted it. They built a brand new house. That's why I had an elevator in it and all these nice things. But the parents passed away. Their kids lived in all different states. They just put the house on the market and they entered into a contract of sale with a purchaser. And what happened was after they entered into the contract of sale, they decided not to sell it because they undervalued the house. And so they realized it too late and they wanted to get more money for the house. The people that wanted to buy the house, they were like, no, we want this house for this price. They wanted specific performance. They wanted this particular house. And the argument they made was, there is no other house like it. Money is not going to make us whole. We want this particular house because it has these specific attributes and we're not going to be happy with anything else. I don't know what happened with the case. I didn't follow up once I realized I wasn't getting it, but specific performance was the clause here. That's what they wanted. This particular house, money was not going to make us whole. That's now remedy number 2. And when you have a breach of contract or an anticipated breach of contract. The last one I want you to know is an injunction. An injunction is kind of like the opposite of specific performance. When you want somebody to stop doing something. So you go to the court and say, I want them to stop doing X, Y, and Z because of A, B, and C. So when you sue somebody for a breach of contract or contractual obligation, sometimes you want them to stop because they're doing maybe a awful job or because it's creating a lot more damage. So you want an injunction granted by the court to stop them from doing whatever it is that they're actually doing. Any questions? Okay. Okay. Sometimes when the court grants the remedy of, monetary damages, they're trying to put the party back in the position they would have been if the contract had actually been carried through. So just kind of like keep that in mind. That's like a listening type of thing. Now, how do you actually calculate monetary damages? There's all different ways to calculate monetary damages, and the book talks about a couple of different ways. I'm going to ask you generally, okay? Like, I'm going to give you like one common theory because, again, I recognize this is a 100 level class. In college, it's not law school. So I'm going to go kind of easy on you. And what I'm going to do is I'm going to use my handy dandy whiteboard thingy. Where is it? Let's see here. Now that I know how to use it, I'm like, oh, this is fun. Okay. Okay. So let's say I am, I hire somebody to build a building for me, a hotel, let's say, and the hotel is going to have 6 rooms in it that I could rent out for $1,000 per night. I guess that's a lot, right? Whatever. Just go with it. So it's $1,000 per night when I can rent it out. And I'm anticipating, because this is going to be a very high classy, you know, hotel, I should be able to rent it out 30 days, no problem, right? They're all going to be, every room is going to be filled. So I am anticipating $6,000 per night times 30, right? Which gives me $180,000. I tell my builder it is a time of the essence. I need this by, we're going to make it nice and simple, January 1st, 2021, because we don't want anything to do with the year 2020 anymore, right? So I need it by January 1st, 2021. It has to be completed. I also recognize that I am going to be spending $30,000 in overhead costs, overhead, per month, okay? So now it takes so long sometimes. Okay, so the builder does not get this to me by January 1st, 2021. In fact, they get it completed 1 month later, February, okay? So there was a time of the essence clause. I needed it by January 1st. If I'm going to sue the builder for a delay, what is the most I can recover to make me whole?
$210,000.
How much?
210.
No. Let me see the chat here, what we have here. 180. So far, nobody got it right. Think mathematically.
It's 150.
150.
My second guess.
Huh? Does it make sense? Let's go over it. If I could make 180,000, because I'm giving you that, I'm expecting to make 180,000 for the month. I know that I have 30,000 in overhead costs. If my hotel is not completed until February, I don't have to pay that 30,000 of overhead, right? I'm not going to be asking for 180 because that doesn't make me whole. That actually gives me a fallback, you know, an extra profit that I would not have made, because I know that the maximum I can make is the 150 because I have to pay overhead costs. So to make me whole, I should be getting from my builder 150. Okay? Make sense? How do you close this thing here? Stop share. Let me see what else here. Oh, yes, go. Okay, got it. Okay, great. So now you guys got it. So if I ask you on the exam, I give you you know, I'm going to give you a fact pattern. So this exam is going to have more, it's going to have longer questions on it, okay? Fact patterns. And you kind of have to think, you know, how to get this. But again, I'm not going to ask you the cost avoided. I'm not going to ask you, you know, like this theory or the compensatory theory or anything like that. It's going to be a fact pattern just like this, and you have to figure it out. Okay, not again, it's not going to be hard. You don't need a, you know, calculator or anything like that. The only other thing I'm going to add to this money thing, it's sometimes the court will add punitive damages. You should know punitive damages should actually ring a bell to you. When else did we talk about punitive damages in this class? It wasn't that long ago, guys. Anyone at all out there? Okay, so punitive damages, when we talked about the case, yes, Marlboro. Thank you, thank you, thank you. So the Marlboro case, right, when the guy died of lung cancer and the court awarded punitive damages because they wanted to punish, I think it was Philip Morris, not, you know, not Marlboro, but they wanted to punish the cigarette company. So they awarded punitive damages like millions and millions and millions and millions of dollars because they wanted to punish the company, right? So punitive damages, somehow it's awarded. Rare that it's done on a contractual case because a contract is between two parties. I mean, I can't really think of any, you know, situations where you want to punish a contractual party, but it could potentially also happen. I just can't think of it right now. So that takes care of punitive damages. Sometimes foreseeability of damages can also be another way to calculate, because you're anticipating how much money somebody would lose. Again, it's just that's the terminology. It's you know, if this was done, if the contract was carried out, they would have made X, Y, and Z. But sometimes if you can't foresee something, then you would not get that whole thing of foreseeability damages. And so the case I actually have here, this is a case of Hadley versus Baxtendale. It's actually a very, 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 very old case. I mean, it's like from the 1800s or something. And I'll tell you briefly about this because I'm sure nobody read it. This case, the essence of this case is about, you know, like this company had their grain thing broke and they hired somebody to fix it. And excuse me. But there was a delay in getting it, and so they were not able to operate, you know, their mill, because that was the only thing that they had that was they didn't have a spare of it to do their, you know, milling and grains and like that. But the person they gave it to fix, there was no way for them to know that they didn't have anything working parts. So even though they sued them, they were not able to recover because there's no way for somebody else that they would lose that money. It was not foreseeable. They didn't tell them. If they had notified them, then they would have been able to actually get the money. But because they did not notify them that this is the only piece that they had, there was no way for them to know, so then they were not charged. Something here popped up, but yeah, except in the end, he didn't properly tell him he would lose profits, so he wasn't awarded. Yeah, that's right. Good. Okay, next case, Parker versus 20th Century. I don't agree with the outcome of this case, but I'm still going to ask you about it. And it's a case I generally ask about. Parker versus 20th Century. Perhaps, maybe somebody read about it. Shirley MacLaine. Does that name sound familiar? Anybody want to tell me about Parker versus 20th Century Fox?
Yeah, this famous actress from the 60s, she signed a contract with 20th Century Fox for some specific movie. I forgot the name of it. But basically, she had the right to pick up the director. It was written in the contract, and also another person of the staff, forgot the name.
That's okay.
Of that position. So she signed the contract. They're supposed to pay her $750,000 for, I think, a month and a half or 2 months of her time, whatever it took to get the movie done. And once she signed the contract, after a month and 2-3 weeks, I think they called her back and they told her that the project failed and they have another movie for her which is completely different movie, and they have to go to Australia to get it done there, and she doesn't have the right to pick up the director and the other person of the stuff. So they promised her to pay her exactly the same money that she signed for the first time, but she wasn't happy with that, and she took them to court.
That's right.
For yeah. And
now,
she won, yeah.
And now, what the other thing, you did a great job, Mar, very, very good. The only thing I would add also is that the first movie she had contracted for was like one where she was going to sing and dance and showcase her skills.
Yeah, it was a musical. Yeah,
it's
correct.
a musical.
I forgot about it.
Yes.
Yeah, the other one was some Western or some crazy story. That
Western, exactly,
there.
where she was not going to be able to showcase her talent. So the court gave her the $750,000 because they said, you know, it's not her fault that they changed the movie and it was inferior in nature to her talent. So therefore, she got $750,000 for doing nothing. So the argument could be made, right, that, you know, perhaps she turned down another working opportunity in order to take this first opportunity. And now that she lost it, she was losing both opportunities, and that's why she should have been, you know, awarded that. But the reason I don't like the outcome of this case is because I didn't see that there was any mitigation of circumstances. It wasn't like, you know, they didn't ask her to see, you know, did you try to find another job? Did you try to get the other, you know, a movie or something like that? Because essentially she got paid to do nothing. And yes, it was not her fault, but there was no mitigating circumstances. But that's just my opinion.
But another big argument was that they took the right out of the second contract, that she can pick up the director and the other person. So
yeah, she was losing control as well. That's right. Yeah. That's right. So something just fell. So those are, you know, some of the things that are part of the remedies, performance and breach. Let me just see if there's anything else I want to cover. I talked about mitigation of damages just briefly now. I don't see that in my notes, but I'm going to just talk to you about mitigation of damages. Generally speaking, you have an obligation to try to reduce the amount of loss that is going to be based in a contractual relationship. So if I am not going to be able to perform my end of the bargain, I should at least try to not make it a complete loss. Try to kind of like solve the problem a little, remedy the situation between us. So that's all I have for chapter 18. So like I said, the next time we meet, you don't have to log in to Zoom or anything like that. Blackboard is going to have the exam at 6:30. It's going to show up on, let me see here, what day is that? The 21st, and the 21st is I want to say it's a Wednesday. Let me just look at my calendar. Yes, it's a Wednesday, so that's good. And then after you finish that exam, the next time we actually meet with one another, it's going to be a brand new, now the third of the semester, which we're going to be talking about sales, and sales are not really that fun or exciting for me. So next class is the 28th. Hold on. Yeah, the next actual class is the 28th. I may be doing a video for you, which means it's going to be me talking like this, but pre-recorded, and then I'll send you a YouTube link with the video, and then you can kind of just watch it on your own time. It'll also have a secret message in it, so you'd be able to still copy that down and use it for attendance purposes. So you can just kind of put down, like, you know, for the classes for, you know, November 8th, whatever the next day is, October 28th, here's the secret message, and then you'll be able to listen to it on your own time. You wouldn't have to actually sit through class. But I'm going to email you and let you know which way. If it's going to be live, I'm not going to email, but if I send you a link, I'm going to let you know that you can just watch it whenever you want. So October 21st, exam 2, the 28th is a video. That's what we're going for. I will let you know about the 28th for sure as it gets closer, but probably most likely. Any other questions?
What about the week after the elections? No, that was a joke.
Oh,
no, I'm joking.
I don't know. I'm going to think, I don't know. I will tell you something. Yeah, I mean, it's there's so many things hinging upon this election, so we'll see. We shall see what happens. But anyway, that's for another date and time. If any questions about topics or materials, feel free to email me as always, and have a great night.
Have a good night, Professor.
Good night.
Good night.